Welcome to week 4. It's hard to believe we're this far into the course with just a couple of more components to follow our discussion this week. And this week we've moved from adulteration, which talks about the content of what the food product is, and now we're moving into that label that provides that consumer all the information that they're looking for in terms of nutritional information, claims about the product, and we're going to be talking about this prohibited act of misbranding. The structure for this week, we're going to look first at the FDA and its general requirements towards food. And then we're going to look at its special requirements towards dietary supplements. And we're going to round out the discussion by taking a look at the USDA process and, again, taking an opportunity to see really how vastly different the agencies treat, labels, and enforce these prohibitions on misbranding. So we always begin at the top by looking at the statutory sections, and the readings today demonstrate, especially in this first half when we're talking about general foods, how broad this definition of label means. And I think if you walk away from this class with nothing else, it's that this lesson of these terms that we take for granted, food, labels, are really loaded terms when we look at the statute. And so we have two terms in the statute. We have label and labeling. And I also included in here this additional definition for immediate container because that is referenced in subsection K here in the terms of what it means to be labeled. And so generally when we're talking about a label, I think most of us have an idea of what that is. It's the box, it's the wrapper that goes around a can. These are pulled from the guidance document. This image is pulled from the guidance document on labeling. And there are two technical components to a label that you may be familiar with. And one is called the principal display panel, and the other is called the information panel. And the principal display panel, to think of in a non-regulatory way, is that thing that you're going to see when you're on the grocery store shelf, and the first thing you see. It typically has the name of the product, has a marketing image, and some information about the net weight, the contents. You'll see that at the bottom. And then you'll see some claims about what the product does. And then if you turn the product to the side or to the back, you have this information panel, and that has the nutritional facts panel, the ingredients, where it's been manufactured or distributed from. All of that technical information is there on the side. And so that's the two technical components that we're talking about. And there is a whole host of regulations about what goes into those areas and specific categories for canned foods, specific regulations for juices, a whole wide gamut of things that we can get into if we got technical about how to label a product. And that's something you may encounter in your experience in a facility, and it may be something that you just leave to legal counsel to work with or to a lab that's doing the nutritional fact panel information for you. Really what we want to focus on for this course is to look typically at the principal display panel and look at it both for food products and look at it when we get into the next component on dietary supplements. That's typically where you're going to see claims about the product. Claims can be a whole wide range of things that we see, and so that's where we'll kind of focus when we talk about some of the challenges and the challenges in the reading about First Amendment and free speech. But this is the technical idea of what it means to be a label. And for a long time, that was what a label meant. And we have in this reading some discussion about the expansion of that definition of label and this criteria of when a label means a book that's included in the marketing as one of the examples, some promotional literature that goes with the food item that you're selling. We have this overlap with the Federal Trade Commission that we talked about in the first component, the Federal Trade Commission looking at that truth in advertising, and where that line for marketing, where the Federal Trade Commission would come in, and where that line for the FDA comes in. And that will become more clear when we talk about dietary supplements as well. But we've seen this expansion not only to books that are included in the readings, but I've included a warning letter here that looked at meta tags. And meta tags are those elements in the background of websites that help drive keywords and traffic for websites. This example had references to cancer and the ability to cure cancer and different items like that. And the FDA issued a warning letter saying these meta tags were a part of the label under this definition that we see at the very beginning. And so amazing to see this hidden component that the consumer may not ever see, but the consumer may be driven to by using the search terms as included in the warning letter. Included another warning letter. These are increasingly common. I used to encounter very few, none really, warning letters that referenced Facebook or Twitter or other social media. And now I see a client that comes in with at least one a year, if not more, where the FDA has gone to look at not only the website to see what claims are on the website about products, but also to look at Facebook promotions, Facebook posts that are talking about the product. And as we'll get into in dietary supplements, even what consumers are saying about the product and the comments on particular posts being included in this idea of what a label is. So when we talk about labeling and we talk about misbranding, we need to expand what we think about beyond that principal display panel, beyond that information panel. And there's a lot that we need to address. We need to be really technical when talking about those traditional components of a label, but then we also need to put on this regulatory mindset when we look at all the marketing that goes on. And we need to look at it from an FDA perspective. We'll talk about in this later component the FTC mindset about it. And as we get into I think the final lecture in week 6, we look at litigation, and a lot of litigation comes around what this label means, and it's not always looking at the box of the product. So we really need to broaden our scope of thinking about labels. So not only do we need to look at this idea of what is a label, we also have to look at what is this prohibited act of misbranding and what does that mean. And I will tell you that if of the areas of practice that FDA misbranding is the most challenging, and if you look at USDA misbranding, probably the easiest, and we'll get into why that is. But the breadth of the term for misbranding is so broad here that it can really encompass a lot of activities. And I've included the general definition that we have of what it means to be misbranded, and really focusing on false and misleading representations. But then when we look at the definition and the whole statutory section for what it means to be a misbranded food, and that's in section 343, I briefly covered A through D, but there are A through Y, that many subsections that talk about misbranded food. Everything from imitation to misleading to selling under another name. Food allergens has become a really big area. That's listed in here further down on the list. All sorts of things get caught into this definition of misbranding under 343, and it's a massive scope, and it really gives the agency the broadest authority to look at containers, look at labeling, and bring these enforcement actions and get changes made to labels. So our readings focused on 2 types of challenges, and the first 2 readings, the law review articles, really were meant to highlight how this constitutional challenge is still out there. We've talked, the readings get to this, we've talked around the edges of what a constitutional challenge might look like, but we haven't seen that yet directly. And we can kind of speculate, as the one reading did, about what that might look like, and another reading just looking at what cases in certain areas have brought within FDA regulated products. And typically what we can agree on is that when this is going to be a constitutional challenge, it's going to be under this commercial speech doctrine. And so what we know about the commercial speech doctrine is it's providing a step up of protection. So we kind of go from not having any protection. If it's a misleading advertisement, we get no protection. And then if we have pure free speech, for example, this lecture would be, if I went on some sort of political rant, that would be pure free speech, and that would get the highest level of protection. And then if we have this commercial speech, we're somewhere in the middle. We're in that intermediate level of scrutiny, and we have this whole criteria that we look at to see whether or not the government has a good purpose for regulating and tampering down that business or that industry from making the type of speech that it wants. We have this whole commercial speech doctrine. It's important to look at, important to see, and when that challenge does come up, that will probably be the angle that it looks at. But we're just asking from the very beginning, is this commercial speech? And we get into this idea about the books being tied to the products, the promotional materials being tied to the products, and we have to ask, not only is the product itself doing more than proposing a commercial transaction or relating to economic interest, but then are these, because of course we're going to say anything on the label is meant to induce the purchase. We're going to make sure the images on the label and the facts on the label, the claims about what the product does, are meant to induce the customer, the client that's going down to the grocery store, to purchase that product. So no doubt that everything that's on the product itself is going to be commercial speech. And now we have to ask, what about that coupon literature? What about that informational pamphlet? Everyone has a website these days. Is that website considered commercial speech? If we have a third party that is promoting our product, is that commercial speech? And so these are the questions that we have to ask as we look at each of the materials that we create to market our products, and to determine whether or not, if the FDA comes and attempts to regulate that speech, if we can then come back and say, this is my First Amendment right to make these claims, to get the consumers to purchase these products and make that challenge. And this is the difficulty that we have in labeling. We want to make sure that we're doing enough on the label to be marketable, but then we're trying to balance this ability to comply with the law and not raise a public stink through warning letters and enforcement actions about what this label is saying and the truth about it, the truth of what's being said, or the marketing that's there. So I think that's in part why we haven't seen constitutional challenges, is that there's this desire to keep the PR about that a little bit lower. So not only do we have constitutional challenges, which are harder to find, but I think there eventually will be a case challenging that, and if it's not in the traditional food realm, we'll see that the dietary supplement realm really invites that type of challenge. There will no doubt be statutory challenges, and these are very common. And what's particularly amazing in this case that I gave you was from 1993 relating to pet food, but that standard of misbranding and labeling applies to food in this type of case is identical to what you would see in a human food case. And what's absolutely amazing about this case is when you get into these standards about challenging, misleading, or false, what that definition means in the statute, those standards, even though they're cited in the 1993 case, they go back to cases interpreting the original Act, 1906 Act, cases from 1914, 1930, 1950s. This case law is over 60 years old, in most cases older, and we're still interpreting the provisions of the Act in that way. And it's just mind-boggling that our marketing has come light years from where we were in the 1900s, early 1900s, to where we were in the 1950s, to where we are today, but the law has stayed the same. Absolutely amazing. And you can see this sort of, I don't know, almost offensive way that the FDA determines whether or not this label is misleading or false. And we don't assume, you'll hear this a lot in the law, that what would a reasonable person think? And what would a person in similar circumstances reasonably interpret this to be? We don't use that. We go down to the base sum, and we assume that the consumer reading this label is ignorant and unthinking and the credulous. Amazing that this, and you could see the culture of the early 1900s, the early 1920s producing this type of standard, but the fact that it remains is just amazing. And it also is beginning to be a sore subject between the FDA and the Federal Trade Commission. The Federal Trade Commission does not like this standard and does not use this standard. It uses the reasonable person standard. What would a reasonable person interpret this label to be? Would they think that this label is misleading or false? And so there is this tension between the two agencies, and if there is going to be a challenge, I always try and push clients to a challenge through the Federal Trade Commission and get into this jurisdictional dispute between the two agencies, because if you can get into the FTC realm, you have a better chance of winning a false and misleading challenge than you do on FDA turf. Other elements from this case that we saw is that not every aspect of the label has to be false or misleading. They don't necessarily have to prove that it actually is, and there's no need to say, here is John Doe, and John Doe bought this product and was confused, and here's John Doe's evidence and testimony to prove that they were actually misled into purchasing this product. We don't need that. We simply need to speculate based on the standard of what an ignorant and unthinking consumer would believe this label to be, and make the case there. Not only is this standard different than what the Federal Trade Commission does, it's different, as we'll see in week 6, about what a labeling lawsuit looks for when we actually have someone who has bought the product and is suing and is saying, I was misled into buying this product for the following reasons. So the FDA really is alone in using this standard, but it is still the standard that's used for traditional food products, traditional beverage products, in terms of determining whether or not we have a false or misleading product. So we've covered both constitutional and statutory challenges, and again, this is going to be just for traditional food and beverage. And the next component, we're going to get into what this looks like for dietary supplements and the types of claims dietary supplements make. And then, in final component, look at the USDA labeling and misbranding and see a radically different world and how they enforce and create labels.